Welcome to Case in Point, produced by the University of Pennsylvania Law School. I'm your host, Steve Barnes. In this episode, we'll be talking about new approaches to assessing and drafting criminal codes. That is, the law that encompass what the criminal offenses and various punishments are of a given jurisdiction. With us today to detail his innovative work drafting criminal codes in the U.S. and around the world is Paul Robinson, the Colin S. Diver Professor of Law here at Penn Law and the Director of the Criminal Law Research Group. Thank you for joining us. Well, let's get started, please, by telling us a little bit about your project in Somalia.
Well, as you've probably seen in the news, Somalia is a difficult place at the moment. A lot of terrorism. Al-Shabaab is an Al-Qaeda affiliate of sorts. But at the same time, there is actually some progress on the ground. There's a fledgling government. It's no longer a failed state. It's sort of a very fragile state. Of course, there's a history of sort of competition among the clans. That plus the terrorism makes progress difficult, but we're making real progress. Our project is with a criminal code, a new criminal code for Somalia. And what's sort of exciting about that is it is a project that has the potential to bring the clans together to help them work on something that they see as a country. A criminal code is a criminal code for the entire country. So in some sense, it's a unifying project, and it's relatively exciting.
So the criminal code is, in essence, just a full body of laws that lay out what the criminal offenses are and their attendant punishments. Is that correct?
Yes, as well as defenses. I mean, it's a special challenge there because, of course, Somalia is an Islamic country. There is a certain amount of natural tension between Sharia, Islamic law, and some international norms. A lot less conflict than you'd think by reading the press, but there are some points of tension. So part of what we do is help them navigate those points of conflict. Actually, most of our work is the same work we'd be doing and have done for other non-Muslim countries or states in the United States. But that's sort of an extra dimension of the problem, is trying to resolve those Sharia international norm potential points of conflict.
Great, and certainly want to talk about your work with states here in the U.S. and with another predominantly Muslim country regarding criminal codes. But so how does it work? That would be great to know. So when you're looking at a country like Somalia with all of its challenges, with whom do you engage in this project? Like what government entity or entities?
Right. The project, and this is the case with most countries, the project is supported by a group of international organizations, NGOs, some UN organizations. In this case, the leader of that group is the IDLO, International Development Law Organization. They're organizing it, but obviously it's the Somalis that, at least in our view, are the ones who are in control. They are our client, not the internationals. That's actually sort of an interesting point of tension, because the internationals, of course, naturally want international norms to be expressed in the code. But as a political matter, that's simply not possible. It's not within our authority, even if we wanted to sort of force the Somalis or any other country to pick up international norms. And even if we could force them, they would just undo it as soon as we were off the scene. And more importantly than that, frankly, I don't think you can have an effective criminal code that doesn't capture the shared values of that community. They're the ones who have to live with that code, not us. So part of our role is actually to work through this criminal law drafting process, and while we certainly inform them of what international norms are and the potential points of conflict, at the same time we sort of support their own interests in having the code reflect theirs. We certainly, in some cases, deal with the tension between the Somalis and the internationals on some of these points. In the end, it's working out pretty well. I think at this point, everybody's happy. I'm sure we're going to hit some bumps in the road. We always do. But so far, things are moving along well.
So you're working with the judiciary, with the executive?
Yes, well, the Somalis are a strong executive. They have a form of government now which is temporary, it's transitional. There will be, in another year or two, there'll be a slightly different form which will be, it will have somewhat more independent judiciary. I would say at the moment their judiciary is not sufficiently independent that it ought to be treated as independent. We don't take it seriously as independent at the moment. But I think things are changing there. So for the most part, we're dealing with the Attorney General, the Chief Justice, the Minister of Justice, and their sort of major officials who have some role in the criminal justice process. They're all involved in this project.
Mm-hmm. And what's the timeline for this?
They would like it done in a year, and I think that is feasible, but we're going to have to move quickly to do it. We're on track to meet that. Mm-hmm. I'm going over in, I don't know, next week, I guess, for a week. And so we'll do those kind of things regularly and make some good progress.
Fantastic. Now this project follows on the heels of your work in the Maldives. Could you tell us a bit about that and what the outcomes were with that project?
Sure. Well, the Maldives, of course, is another Islamic country. Our work for them was, in fact, enacted as a criminal code last year. So we're seeing how some of this stuff is actually working out in practice. The Maldivians had their shared community views were not significantly different from international norms, right? On the other hand, they are also devout Muslims. So to them, the tensions between Sharia and international norms, and in some cases their own shared intuitions of justice, were something of a challenge. And a lot of the particularly good work we did for them was to help them resolve those challenges in some kind of principled way. Just to give an example, they are really a de facto death penalty abolition jurisdiction. But of course, at least some of the hudud offenses in Islam, that is the offenses that are specifically mentioned in the text of the Quran as having certain penalties, some of them have the death penalty. So it's a natural tension if you're a devout Muslim. But culturally, your society simply isn't comfortable with the death penalty. What do you do? Our solution to them on that was to point out that Islam actually has a strong tradition of the proportionality principle, that the seriousness of the punishment should match the seriousness of the offense, a standard Western principle of justice as well. Well, if you believe in proportionality, and if you believe that the death penalty is the uniquely most serious sanction, logically, as a matter of principle, it ought to be reserved for the most serious offense. So the provision in the Maldivian draft that we prepared for them was one that said that they did have a death penalty. Mm-hmm. But it was a death penalty that was only available if one could not imagine a more serious offense than the offense at hand, mm-hmm. which meant that as a practical matter, that was probably never going to happen. Mm-hmm. But it was a principled resolution of that point of conflict that allowed them to be good Muslims and to have a code that reflected their own cultural values.
So you've talked a lot about resolving some of the challenges and tensions that come up when working with government entities on criminal codes. Could you tell us a little bit about your methodology and as well the Criminal Law Research Group?
Yes, both of these projects that we've talked about for Somalia and the Maldives are both projects of the Criminal Law Research Group, where we were commissioned by some international organizations to do the work. The Criminal Law Research Group here at Penn is really a sort of in-house, sort of a small law firm, really, that has as clients only governments or NGOs. We see ourselves really as problem solvers. That is, yes, we have some considerable expertise in code drafting, for example, but we do a lot of other things as well, anything really relating to criminal law policy. And in each one of these cases, each one of our clients has a special problem, and our job is to bring together the resources to get it done. So yes, we bring our expertise, but we also bring sort of an access to whatever experts we need for that particular project. And the two projects we've talked about, we reached out to professors in Islamic studies, for example. And of course, the Criminal Law Research Group itself is a sort of a unique in that it is a group of very, very smart and dedicated students. So, basically, they're all law review editors. They're the top of their
students.
Yeah, law students, the sort of top of the class sort of folks who really get into the project, are really, for the most part, thrilled by it and get into it. That intelligence, that energy translates into an ability to solve nearly any problem, whether we start out with that expertise or not. At the end of the project, we have that expertise, and we, for the most part, pride ourselves on trying to know more than our clients do about a particular subject by the time we get to the end of the project.
Fantastic. So it's that same methodology you used recently with the CLRG project with the Pentagon.
Sure.
Could you describe that to
Sure.
the extent you're able,
Sure.
please?
Right. So you probably have heard of the Special Operations Command. They tend to do all the services have some involvement, but they typically run interdiction operations, usually through the sort of stuff you read about in the newspapers. They go out and get Osama bin Laden, or what we've seen a few weeks ago, some other search and kill or detain, serious combat situations. But their mission is actually quite a bit broader than that, and they came to us with a project which I thought was really quite inventive. The question was whether we could use domestic law, that is the law of a lot of other countries around the world, that country's law. Could we use that to detain FTFs, as they call them, foreign terrorist fighters, before they got to the battlefield with Islamic State, or after they'd been on the battlefield with Islamic State and had that training in ballistics or explosives before they could get home and use it? Could you interdict them through legal means? And so we ran a pilot project for them in a number of countries, different sorts of countries, both sending countries and transit countries to FTFs.
I'm sorry to interrupt, but just to make sure my head is on a swivel here. So you're talking about a foreign terrorist fighter, in other words, someone who is not from the U.S., going from, say, a European, African, Middle Eastern, or whatever country to a place like Syria or Iraq,
Right.
and using the domestic laws of, say, whatever country that either sent them or is receiving them, in this case Syria or Iraq.
Or maybe just a transit country.
Okay.
They may be landing in an airport to make a flight connection 4 hours later. But if you know that they have child pornography on their laptop, and that country has fairly strict laws about child pornography,
So you could arrest them in the airport.
they
on
take
that
them
law
there, yeah,
versus a
right,
terrorist law.
right. I mean, what's particularly useful here is that the military does have or the U.S. government, through a variety of sources, has good intelligence gathering capability, and every embassy, of course, has a legal attaché who knows the local legals. You can take those two assets, and if you do the legwork to figure out what's the kind of conduct that foreign terrorist fighters typically engage in that is a crime under some domestic law somewhere, and you put that together with the intelligence information about where they're going to be, how are they going to get to the battlefield or back to it, you can figure out these points where, yes, you can detain them. You can get some local government to detain them. And the kinds of conduct they can be detained for may not be a terrorism offense. In fact, most countries in the world, unfortunately, don't have terrorism offenses yet, or to the extent that they have them, very, very difficult to prove because it involves conduct somewhere else out of jurisdiction. But offenses like fraud, theft, identity theft, weapons violations. I think I've mentioned the pornography, child pornography offenses. These are all offenses for which there are serious criminal penalties in most countries in the world. And you can put those together with the FTF who's committed those offenses and hold them under that domestic law.
So it's a Pentagon project, but is the U.S. Department of Justice or the FBI the lead agency, so to speak, going after these folks, since it is a law project?
No, it's actually the Special Operations Command that is coordinating this. They certainly have State Department, Department of Justice, FBI involved, but at least the project started with the Special Operations folks because they're the ones who have as their mission the interdiction of the FTFs.
Now, you and the Criminal Law Research Group are also doing criminal coding work for states. What are some of the projects, and what are the insights and outcomes from those?
Well, right now we're doing a project for we're drafting criminal code for Delaware. We've done criminal codes in the past for Illinois and Kentucky. Those are still sort of wrangling with the politics. Delaware, we're still in the middle of the drafting stage. But most states in the United States have the same problem that these states have, and that is in the 60s and 1970s, 3/4 of the states adopted modern criminal codes based upon the American Law Institute's Model Penal Code. And those codes were beautiful. They were streamlined, they were direct. Any adult could pick up that code and read it and know what the law commanded of them. But since that time, there has been a serious degradation as statutes upon statutes were added and amendments were made without much regard for what was there beforehand. And the new statutes, instead of integrating into the codes, typically are just layered on top, what they call the sort of crime du jour phenomena.
Do you mean an example, please?
Oh, there's some headlines about somebody's car being stolen when they were in it. And the legislatures want to show their constituents that they are up on things and they're doing something about it. So they're going to create a new offense called carjacking. Well, it's not as if this was not already a serious offense, right? Stealing somebody's car from them if they were in it. I mean, you didn't really need a carjacking offense. Or home invasion, right? Make up this new offense because you've had a series of these kinds of offenses committed. They're in the headlines. The problem is because there already exists plenty of statutes that prohibit this conduct, layering a new offense on top of it simply creates complications. The offenses may be inconsistent, they may have inconsistent penalties, and there is an effect of creating just a mountain of problems and irrational inconsistencies by doing this year after year after year. In fact, when we go into these jurisdictions and we try to streamline their codes to sort of get back to a nice clean form where we can actually define non-overlapping offenses, typically the size of the criminal codes are reduced by like 2/3 or 3/4 because so much of that is just unnecessary, confusing, problem-creating overlaps. So we do this for a lot of states, but most states have the same problems and are struggling trying to figure out what to do about it. I'm actually hopeful that if Delaware can pull this off, they can be a model for a lot of other states in trying to fix their criminal codes so people really can know what the law is.
Right. So with that, what is the big takeaway or takeaways you'd like lawmakers to glean from this work moving forward?
Well, I think they have to appreciate the destructive effects of this sort of crime du jour process. And this is sort of the unfortunate dark side of active democracy, right? We want our legislators to be receptive and responsive. We want to have the feeling that when there's a problem, they're on it. The problem is in the case of criminal law, the solution to that problem probably has nothing to do with a new offense that criminalizes what was already criminalized, but in a slightly different way. That tends to just make things worse. The real source of the problem may be, how much have you invested in your police force? How good is their training? What have you invested in job creation opportunities? Have you built up the kind of social institutions that will culturally promote strong moral values? I mean, there's so many things that one could do that would have a real effect. The problem is they're all sort of longer term and complex, and some of them are costly. It doesn't cost anything to create this new offense. It's an easy lever for a legislator to grab. The problem is it has detrimental consequences. It really, it degrades the quality of justice within that system. So the trick is there something that we can do structurally in the criminal justice reform process to get legislators to reach for a different lever, a lever that's not so destructive? One of the things I've written some about, I think there are a number of things that a state could do, but they're all a challenge. It's a big item to get legislators to operate differently than they have in the past when it comes to law and order legislation.
Speaking of law and order legislation, you've found something interesting about public opinion in the face of how some legislators approach that law and order type lawmaking. Could you describe that?
Well, one of the things that we've done for states, in addition to the criminal code work, is doing studies of the offense grades that they give within their criminal codes, most of the time showing that there's enormous sort of irrationalities in how they grade different offenses. But also one of the things we do is empirical studies where we test the seriousness of the offense as reflected in the offense grade.
Meaning the punishment.
That the legislature has given to that offense as compared to the seriousness, the relative seriousness of that offense as their constituents see it. And one of the things that these studies had shown is an enormous disconnect between those two things. That if you went and asked the constituents, you gave them 20 offenses and say, rank order these as to seriousness, it would come out dramatically different than the criminal codes do in many cases. If legislatures really want to be good legislators who represent their constituents, they have to stop listening to the headlines, and they got to start listening to, the quiet hearts of justice in their constituents, not the screams of the loudest protester.
So you've talked quite a bit about your work with the Criminal Law Research Group, and what's very fascinating to me is that CLRG, under your leadership, is comprised of students. So what, in your view, do students get out of being involved in the CLRG?
Yeah. Well, if you ask them, obviously they're going to tell me that it's a useful exercise. But when I hear it second or third hand, what they tell other students is that it really is frequently the most significant experience in law school. And I think part of that is because it is challenging the way real legal education can be challenging. The work is full of ideas and full of intellectual challenge, but it's the real world. The idea that they can bring their talents and their energy to really make lives better for some people somewhere in the world, to students, that's something really quite special. In fact, our problem often is they get almost too involved in it. We have to sort of monitor how much work they're doing, because it's too easy to sort of just get drawn in. But yes, they have, and usually when I go overseas, I usually will bring one or two students with me each trip, usually a different set of students each trip. And for a lot of these students, they've not been overseas at all. To be overseas and to be in the middle of those policy discussions with governmental officials and players in the criminal justice process, it's a real eye-opening experience.
It sounds fantastic. So, follow-up question, and potentially the last question here, how does this inform your own research? Because you've got a very wide body of criminal law and related research.
Well, I certainly write about these topics. I write about what's the appropriate structure of criminal law. I started as a criminal law theoretician, I still am. But I think nothing is more effective than a practical theory. That is, a theory that's grounded in the real world, that could work in practice, not disconnected from the challenges of real live criminal codes. So I've written about the appropriate structure for criminal codes, but I've also written about the process and some of the crime du jour problems, the degradation problems that I've talked about. So that, in a very direct way, it is a research topic for me in itself. But even when I'm working on other work that's unrelated to the CLRG projects, I think it gives me an appreciation sort of for how the world works, or at least how the criminal law world works, which probably affects everything I do. Whatever the criminal law subject I'm writing on, part of what influences my judgments is that experience of seeing it work in practice. When I was a very young lawyer, it seems like 100 years ago now, I was a counsel for the United States Senate Subcommittee on Criminal Laws and Procedures. We were processing a federal criminal code bill. And it was probably the most educational experience of my life to sit in on those markup sessions and hear lawmakers and staff debating the provisions of the draft criminal code, because you could see this was an instance in which good arguments could really make a difference. Good arguments could translate into a more just world. And if you're a principled person and you're thinking deeply about the subject, that translates into good arguments. So to some extent, this kind of exercise, the exercise that the students go through, in part it's what drew me to being a law professor, and I think it guides most of the work I've done as a law professor.
That's great. Well, that's a fantastic way, I think, to end the episode, and thank you so much for joining us.
My pleasure.
It's been a really informative discussion, and I certainly appreciate it. And we look forward to you, the audience, joining us for our next episode of Case in Point. Thanks a lot.